fraudulent misrepresentation in contracts can have serious legal and financial consequences. Understanding this concept is crucial for anyone involved in business transactions or contractual agreements. Fraudulent misrepresentation occurs when one party deliberately deceives another to induce them into a contract, resulting in harm. It is the most serious type of false statement in contract law. For instance, selling a crystal ring as a diamond is a clear example of fraudulent misrepresentation. To prove fraudulent misrepresentation, several key elements must be demonstrated. These include a material representation that is false, knowledge of its falsehood or reckless disregard for the truth, intent to induce reliance, actual reliance by the other party, and resulting damages. Examples of fraudulent misrepresentation can be found in various contexts. A used car dealer might claim a vehicle is accident-free when it has a history of major collisions. A company could inflate its financial performance to attract investors. In real estate, a seller might conceal significant structural issues from potential buyers. Interestingly, silence can also constitute fraudulent misrepresentation in certain circumstances. This occurs when there is a duty to disclose information. For example, a financial advisor withholding information about risky investments or a home seller failing to reveal ongoing water damage after mentioning roof repairs. The importance of fraudulent misrepresentation in contract law cannot be overstated. It renders a contract voidable, meaning the misled party can choose to rescind the agreement. This protects individuals and businesses from being bound by contracts they entered into based on false information. Defendants in fraudulent misrepresentation cases often rely on common defenses. These may include arguing that the claimant did not rely on the false statement, that the statement was merely an opinion or sales puffery, or that the claimant knew the truth before entering the contract. It is important to note that time limits, known as statutes of limitations, restrict how long a party has to file a fraudulent misrepresentation claim. These deadlines typically range from 2 to 6 years, depending on state laws. The clock often starts when the misrepresentation is discovered, not when the contract is signed. If you believe you have been a victim of fraudulent misrepresentation, there are steps you can take. You may choose to rescind the contract, which involves voiding the agreement and returning any benefits received. Alternatively, you could sue for damages to recover financial losses. In some states, both options may be available. Proving fraudulent misrepresentation requires gathering substantial evidence. This may include written records such as contracts or emails, witness testimony, financial records showing monetary loss, expert opinions, and communication records indicating deceptive conduct. Understanding fraudulent misrepresentation is essential for protecting your interests in contractual agreements. If you suspect you have been misled, it is advisable to consult with a qualified attorney who can guide you through the legal process and help you pursue appropriate remedies.